it to 1.
Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning, council, and welcome to the Tennessee Court of Appeals. I want to first of all tell you how much we appreciate you agreeing to participate in this oral argument via Zoom. It's not the preferred way for all of us to do this, but we believe it's the safest and the best way to continue to do the business of the judiciary in these unusual times in which we're living. Before I get started, or before we get started on this argument, I want to be sure and introduce our panel for this morning. We have Judge John McClarty from Chattanooga, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Even though we're doing this via Zoom, we will follow the same rules and procedures as if we were all in the courtroom together today. So let's keep that in mind as we proceed. Also, I want to share with you, because we are doing this via Zoom, if we encounter any technological problems, everybody just remain calm. We will work through those, and I will promise you that nobody's rights will be prejudiced in any way because of any technological problems that we may encounter. Okay, Miss Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the case, please.
State of Tennessee, X-Rail Shaw Enterprises, LLC versus Town of Thompson Station, et al.
And we will hear from the appellant.
Good morning, Your Honors. My name is Paul Krogh. I'm here on behalf of the plaintiff and appellant, Shaw Enterprises, and with the court's permission, I would like to reserve 4 minutes for rebuttal.
Yes, sir. You have it. You may proceed.
Thank you, Your Honor. This is a case about statutory interpretation. Shaw Enterprises started a real estate development in the town of Thompson Station. Thompson Station had adopted a building code, one of these professionally authored professional codes, specifically the International Energy Efficiency Code. And then in the midst of Shaw Enterprises' project, the town adopted a new version of the code and applied it to the development. This was unlawful because Tennessee's vested rights statute, section 13.4.310, makes these kinds of municipally adopted building codes development standards under the statute's text and allows real estate developers to be grandfathered under them. The vested rights statute that I referred to is a simple concept with a complex implementation in the statute. And fortunately, most of the complexity doesn't matter for our purposes here today. All we really need to look at is one definition. But in general, it's a statutory grandfathering provision. If your development hits a particular threshold laid out in the text, you get to lock in place the development standards that are applied to you at that time. And if you comply with the other complexities in the statute that we can skip over, those standards will apply to you throughout the life of the project, even if the government changes the standards, generally speaking. And the definition of development standards is one of the key ways the legislature has controlled the scope of this grandfathering or vesting right. And we look at subsection K4 in the statute, we find that definition. And the definition is in two main parts. And it says, first, that a development standard means all locally adopted or enforced standards, regulations, and guidelines applicable to the development of property. And there's a long list preceded by including local construction standards for buildings, which I think everyone agrees otherwise, generally speaking, includes this energy code that we're talking about here today. And then there's a second part. There's an exclusionary provision that says it does not include standards required by federal or state law, or, and this is the key part here, building construction safety standards, which were adopted pursuant to authority granted under section 68, 120, 101. And within that exclusion, the part that matters most for us is adopted pursuant to authority granted under this other statutory citation. And if we look at section 68, 120, 101, and if we try to decide whether or not that's the provision that under which Thompson Station was granted the authority to adopt this building code, we'll find that the answer is no. You think about the phrase pursuant to authority granted under, and the plain meaning of that in the way that courts, this court, and the legislature, and people speaking ordinarily use that is, where does the power to do the thing come from? You go to a wedding and the person presiding at the wedding says, pursuant to the power vested in me by the state of Tennessee, I pronounce you man and wife, right? Where does he get the authority to do that, the power? Where does his power derive? You could, looking at section 68, 120, 101, could Thompson Station have adopted this building code if that section were deleted out of the code? And if we look at it, we'll find that the answer is yes, because it does not confer the power to do this kind of thing on Thompson Station. Rather, section 68, 120, is there a question, Your Honor?
No.
I'm sorry. This provision is in the part of the code dealing with health, safety, and environmental protection, and it gives the state fire marshal the power to promulgate statewide building safety regulations. And he can do that by adopting for the state generally these kinds of professional building codes. And the statute goes on and talks about what kind of codes and rules he can adopt, how they're to be implemented, how they're to be enforced, and these sorts of things. And if we look at subsection B7G, there's actually a clause in the statute that speaks right to this authority issue. And it says that, except to the extent that a local law conflicts with that statute, that this section neither grants nor removes local governmental authority to promulgate provisions under home rule charters, private acts, or general state law. So that statute, 68, 120, 101, to which the development standards definition directs us, it explicitly disclaims the kind of power, explicitly disclaims being the kind of provision referred to in the definition.
Also,
yes,
before your time run out, a couple of questions. The trial judge made a distinction between development standards and energy efficiency standards. Is that correct?
He might have, Your Honor. I think he did, right. He said that these energy standards were safety construction standards that were excluded from the development standard definition.
And those standards does not require a vesting of property rights. Is that right?
Right. Well, if the way the statute works is if the rule is not a development standard, then it doesn't vest and it can be updated on you. And so the issue here is, is this code, these types of codes, are they development standards or not? And the real way that they might not be development standards under the definition is if the town acquired the authority to promulgate them under this Title 68 provision. And
then the next question I have then, the status of the project. It's my understanding that the project was completed where your client consented to the issuance of the change of the project according to the standards that the city had adopted in 2015. Is that correct?
They went ahead and completed the project under the new standards. Yes, Your Honor.
Okay. Tell me why this lawsuit was not rendered moot as a result of them consenting to accepting these standards and moving ahead with the project?
Well, I think part of the relief we had asked initially for was rendered moot, Your Honor, but because we did that under protest with the lawsuit pending and a request for damages resulting from having to do that, that part of the suit was not moot. You can still get relief for that.
Does the trial judge make any rulings on the mootness issue?
He did not, Your Honor. Not sure that was raised. I'm not sure the question you've raised was raised below.
Okay, go right ahead. You may proceed.
Thank you, Your Honor. Now, this Title 68 section does say what happens if a local government adopts its own building codes. And there's a provision there that allows them to exempt themselves and the buildings in their jurisdiction from the fire marshal's regulations. But Section 101 in Title 68 there doesn't give them the authority to adopt those codes in the first place. It just says what happens if they do. The authority to do that comes from Title 6, which we would expect being the section dealing with municipal governments. Section 654.502 explicitly gives municipal governments like Thompson Station the power to adopt these kinds of codes. And so, respectively,
the trial court referenced an attorney general opinion in its opinion. I believe it's AG opinion number 13-56 that was rendered in July of 2013. How does that affect your analysis of this question?
No, I don't think that affects the analysis at all because the Attorney General wasn't interpreting Section 13.4.3.10. What the Attorney General there was addressing was how to apply a local building code and the fire marshal's codes in the context of a building that was on the boundary between two jurisdictions. And so the building was in one jurisdiction but was having to tie into utilities in another, and there was a question about whose codes applied. He was not deciding this question we're dealing with today about what the definition in Section 13.4.3.10 means, or where the municipal power to adopt building codes came from. And I think the same is true with the state regulation referenced in the appellee's brief, that's not dealing with an interpretation of the statute we're looking at. It's dealing with the implementation of the fire marshal's regulations that he can promulgate under the Title 68 provision. So for those reasons, Your Honor, we submit that the trial court erred in the plain text of this statute entitles plaintiff to a reversal. If there are any other questions, if there are not any other questions, I will wait for rebuttal.
All right, thank you. We will hear from the appellee.
Hi, good morning, Your Honors. My name is Laura Height with the law firm of Fair and Bates, and I represent the defendants in this matter, Town of Thompson Station. I would like to address Judge McClarty's question first. The plaintiff originally filed a petition for writ of mandamus and asked for damages in the alternative. And by the time the defendants filed their summary judgment motion, which was ultimately granted, they had went ahead and moved forward and completed the work. So they acknowledged that their petition or their request for mandamus was moot, but were moving forward and seeking damages. So the judge's ultimate ruling was they would not be entitled to damages because they did not have vested rights in the energy efficiency standards. So as Mr. Krogh has accurately stated, this case does present an issue of statutory construction, and the specific issue being whether the Town of Thompson Station adopted the energy code pursuant to authority granted to it under Tennessee Code Annotated 68-120-101. And it is the defendant's position, the town's position, that 68-120-101 does authorize the town to adopt its own version of those building construction safety standards, which would include the energy code. And thus the energy code is excluded from vesting under the Vested Property Rights Act. So as Mr. Krogh stated, the Vested Property Rights Act, it was enacted in 2014, and it codifies the requirements for obtaining vested property rights. And the statute, it establishes various vesting periods, which in some circumstances can last up to 15 years. So what the act requires is that the development standards that were in effect at the time a preliminary plan was approved have to remain in effect during the vesting period. And then, as Mr. Code pointed out, the term development standards is defined in the statute, which is what we're here for today. And the definition specifically excludes from vesting building construction safety standards that are adopted pursuant to authority granted under Tennessee Code Annotated 68-120-101. So that statute, under Section A, it authorizes the state fire marshal to establish minimum building construction safety standards, including standards related to energy efficiency. Then under Section B of that statute, it states that those minimum standards would apply to local governments, except under two circumstances, the second of which applies in this case. So under Section B2, local governments may choose to opt out of the minimum standards and adopt their own version of the building construction safety standards, as long as they meet certain provisions under the statute, which are not at issue in this case. And the record before the court does establish that that is precisely what the town of Thompson Station has chosen to do in this case. It has opted out of the minimum standards and adopted its own. So again, it is the defendant's position that the plain language of 68-120-101 leads to one conclusion, that it does grant authority to the town or local governments to opt out of those minimum standards that were adopted by the fire marshal and adopt its own version of those construction safety standards. That includes the energy code. So the energy code is specifically excluded from vesting. Now, it's the plaintiff's position that 68-120-101 only grants authority to the fire marshal to adopt the minimum standards. Thus, the minimum standards are the only standards that are exempted from vesting under the act. So this interpretation, Your Honors, is it would unduly restrict the statute's coverage and is not consistent with the legislature's intent, which are two considerations that can be made in a case of statutory construction. If you read both statutes, Vested Property Rights Act and 68-120-101, it's clear that the legislature's intent was to exclude all building construction safety standards from vesting, whether they be the minimum standards or those more stringent standards adopted by local governments. And the reason for this is the vesting periods established by the legislature can extend over 15 years in some circumstances. Building codes, residential code, plumbing code, energy code, they change over time fairly frequently. So the legislature clearly took that into consideration when carving out this exception for those codes vesting, and that's to make sure that the health, safety, and welfare of the public is considered in the building of the home. And that's the difference. Development standards under Section K4A of the Vested Property Rights, those standards specifically apply to the development of the land. The building construction safety standards specifically apply to the buildings of the homes. So the legislature clearly intended to carve out this exception. If the court were to accept the plaintiff's interpretation that only the minimum standards vest, this would unduly restrict the statute's coverage to those standards, and it would circumvent the legislature's intent. It's also the defendant's position that the plaintiff's interpretation would lead to an absurd result, which the court should consider. Under 68-120-101B, the minimum standards apply to local governments unless they choose to opt out under one of the other two provisions. So there are local governments out there who are enforcing the minimum provisions under this statute. So under the plaintiff's interpretation, those local governments that are enforcing the minimum standards that are excluded from vesting would be permitted to enforce newer versions of the code on property owners, even if an older version was in effect when the preliminary plan was approved. So in other words, if a local government chooses to enforce the minimum standards, those are exempted from vesting. But if a local government like the town in this situation is enforcing its own standards, the more stringent standards, the property owner maintains vested rights. So that's how that would work under the plaintiff's interpretation.
Counsel, answer a question for me.
Sure.
The court, once it was determined that the parties had consented to the project and the building permit, in fact, the occupancy, the agreement to occupy had been granted. Once that's done, why would the court need to make a decision to move on and rule on whether or not the standards were vested or not?
So again, the plaintiff was seeking damages as an alternative. So the energy efficiency codes, the plaintiff claimed, the newer version, caused an increase in construction costs. So they were claiming that they should be able to come back and get that increase in cost, even though their vested property rights were violated. And so below, we actually made the argument that the Vested Property Rights Act doesn't create a private cause of action in order to get damages, which is not before the Court of Appeals today, because the trial court decided to make a determination whether those energy efficiency standards are excluded from vesting at all. The trial court came to the conclusion that if I decide that in the defendant's favor, then there's no need to go to the next question of, well, are they entitled to damages or not? I'm sorry.
Yeah, okay.
Okay. So going back to the absurd, if the court were to adopt the plaintiff's interpretation, that result where some local governments, some developers' rights vest in this local government and they don't vest here, it just would lead to confusion and inconsistency in the development industry. A developer would need to find out going into a development what standards a local government had adopted, whether they were applying the minimum standards or whether they had adopted more stringent ones, just to determine whether or not they were going to have vested rights in those standards throughout the vesting period. It's a much more logical reading of the statute to exempt building construction safety standards across the board, which would provide uniformity and consistency in development. So that way a developer knows going in, okay, I can obtain vested rights in those standards that are related to the development of the land, but I'm not going to get vested rights in those standards that relate to the construction of the homes in the development, which is what the building construction safety standards apply to. So another, and Judge Stafford pointed this out, it's the defendant's position that the language of the statute is clear, it's unambiguous, that it gives authority to local governments to opt out of those minimum standards and adopt their own. However, if the court does find an ambiguity exists, it can look to outside sources, one of those being the Tennessee Attorney General's opinion that the trial court pointed out that clearly interprets this provision as authorizing local governments to adopt these codes. I've also pointed out in my brief that Chapter 780-223 of the Rules of the Departments of Commerce and Insurance Division of Fire Prevention also interprets 68-120-101 as giving authority to local governments to adopt their own version of the codes. The rule specifically states that local governments adopt the building construction safety standards pursuant to 68-120-101, and it references on 3 separate occasions that they are authorized to do so. So those two.
What is the, excuse me just a second, from looking at this from a statutory analysis, what is the significance of the agency making that determination? Because that sort of opens another can, a whole different type of analysis here, doesn't it?
Well, I think that rule basically is, it sets out what codes can be adopted, the newest version of the codes that should be enforced. So it kind of provides a guideline. And so I think it's just more of an outside source just to look to see how the state itself is interpreting the statute. That's more of just to determine, or to look at, you know, if the term is ambiguous at all.
I mean, this is an agency essentially interpreting its own rules, correct?
Well, its own rules, but it's interpreting the statute that was adopted by the legislature. So,
correct, but it is at least saying that this is the anchor that we have, or this is the segue that the legislature has put in place for the local government to do what it's supposed to do.
right.
So I'm just trying to figure out what kind of precedent we give to the agency in saying that.
I mean, under the rules of statutory construction, looking to outside sources, I think that's more of just a guide for the court to look to see. I mean, really, when under the laws of statutory construction, the court shouldn't look to outside sources if the terms are unambiguous. So it's more of, if there is an ambiguity, which we insist that there's not. I think the plaintiff has created an ambiguity, but that would be the only need to just look to that to see its interpretation. I don't necessarily think that it would have any precedential effect on the determination, just to see this is how the state's interpreting it. Also, this is how the Attorney General is interpreting it. That is consistent with the way the defendants are interpreting it in this situation. And so, just to wrap up, on page 33 of the brief, the plaintiff states that had the legislature intended to exempt every building code type rule from the vested rights regimen, it easily could have said so plainly. And it's our position that the legislature did state so very plainly in the statute. It specifically states that building construction safety standards that are adopted pursuant to 68-120-101 are excluded from vesting, and that statute authorizes local governments to do so.
Okay, thank you, counsel. We will hear from the appellant in rebuttal.
Thank you, Your Honor. My friend on the other side says that the legislature's intent to exclude all building construction safety standards from the vested rights regimen is clear, but 13.4.310 doesn't say that. It has this extra language about being adopted pursuant to authority. And nothing in Ms. Height's argument gives that language, that discrete language, any particular meaning. If the legislature had wanted to exclude all building construction safety standards, it simply would have put the period after the word standards. The adopted pursuant to authority language only serves a function in the statute as a limiting device, meaning that some construction safety standards are in, and some, those that are adopted pursuant to a power coming from Title 68, those are out. And Title 68, Chapter 120, Section 101 simply doesn't empower municipalities. It contemplates the existence of a power they have to adopt these building codes, but it doesn't create the power. And if we look at the provisions, it says what happens if they do a thing, or if a municipality does a thing, if a local government does a thing, not a local government is empowered to, or a local government may adopt. The power is contemplated there, but not created. The power was created in Title VI, not created in Title 68. Judge Stafford, you asked, what is the significance of the agency determination referenced in the appellee's brief? And here, I don't think the significance is really anything, not because what agencies do doesn't matter for interpretive purposes, but because the agency isn't answering the same question, right? That agency rule is implementing the fire marshal regulations, the fire marshal's powers under the Title 68 statute. And it's saying, listen, you municipalities that are using your own codes, you have to follow these steps. Here's how we're going to enforce the provisions of that statute. It's not attempting to define development standards in Title 13, Chapter 4, Section 310, and it's not attempting to give an answer to this question, where does that municipal power really come from? It's simply saying, okay, well, there's this provision that allows you to opt out of the state standards, and here are the rules for doing that, as contemplated by Section 68, 120, 101. But my friend, Ms. Height, says that there's a distinction between standards for land and standards for buildings, and that the development standards definition only covers land. But we know that's not the case because the definition includes a specific reference to building construction. It's right there in the statute, and I read it during my opening argument. Ms. Height raises problems about the length of these vesting periods. We've discussed the safety valve provision that the municipality has in our brief. There's also this question about absurdity, and we went through that in detail in our reply. We simply don't meet the requirements of that doctrine here. That's a policy argument Ms. Height's making, not a statutory interpretation. Just last month, Your Honors, the Supreme Court decided Kampmeyer versus State, and we think that decision specifically excludes reliance on those kinds of policy arguments in the face of a clear statute. And unless there are any questions, my time has expired.
Thank you, counsel. We certainly appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We again appreciate you participating with us via Zoom. Ms. Angie, anything we need to take up before we recess court to the call of the next case?
No, Your Honor.
All right, we will be recessed until the call of the next case.
Thank you,
This
Your Honors.
honorable court is in
Thank you, Your Honor.
recess.